Hello, everyone, and welcome to our third weekly webinar. My name is Stacy Sinclair, and I'm the head of Fenwick Elliott's Technology and Innovation Group. Today's topic, of course, is virtual hearings and the future of dispute resolution. We're now nearly spot on 2 months from the start of the UK lockdown, seemingly, hopefully, past the coronavirus, and it's perhaps the perfect time to reflect on just how, in my view, spectacularly, the UK judiciary and courts have reacted to the situation and have continued to deliver such a world-class service despite the conditions. There's been research to show that in the 2-week period from the start of lockdown on the 23rd of March to the 6th of April, audio hearings across the courts and tribunals in England and Wales increased by over 500% and video hearings by 340%. Possibly not surprisingly, but so fantastic to see. And as with any change, obviously there are issues as well as opportunities, and virtual hearings and online courts are perhaps no different. I'm personally extremely excited, as you can see, by the transformation in the courts and indeed the legal profession itself. And I'm therefore delighted and honored that we have speaking with us today on this topic, Mrs Justice Fenwick O'Farrell, the new judge in charge of the Technology and Construction Court. Many of you will know Mrs Justice O'Farrell, obviously over 30 years of experience as a leading barrister in construction and engineering and in information technology cases. Fenwick took silk in 2002 and was made Justice of the High Court in 2016. And we are now delighted that Fenwick is head of the TCC. Fenwick Elliott's senior partner, Simon Tolson, will be discussing with Mrs Justice O'Farrell the change and transformation we've been seeing over the past few months and the opportunities and challenges of virtual dispute resolution. And here now on my screen, you hopefully are seeing the topics we're going to be covering today. The effect of COVID-19 on the courts and hearings, the trends and issues that we're seeing arising, namely fairness, witnesses, experts, adjudication enforcements. We'll then move on to top tips for advocates and the parties, a brief look at what the rest of the world is doing in terms of arbitral proceedings and mediations, and then ending on a discussion of the future of litigation hearings and what we're likely to see going forward. Now, before we begin, I just wanted to mention that we are taking questions at the end. So please do submit them as we go along. You should see on the right-hand side of your screen questions panel. Your questions will be put to Simon and Fenwick anonymously, so please do keep them coming as you think of them. Everyone's on mute, so don't worry about that. So without further delay, Fenwick, a very warm welcome and thank you very much for taking the time to join us today. And Simon, shall we start, Simon, moving on to our first slide, the effect of COVID-19. Perhaps let's start with an overview of what we've been seeing over the past few months and your thoughts and experiences of just what's happened since the middle of March.
Yeah, I mean, I think it's been a remarkable period, and I think that's probably the experience of most lawyers and members of the judiciary and arbitrators over this last 2 months. I think what I'd probably start by saying is that there's been a remarkable sort of ability, I think, by the legal community to adapt to working in a different world virtually through the advent of the lockdown, particularly since the end of March. And to utilize technology that was there already, but use it in a way that none of us had really embraced before, and to make use of technology in a way that does allow effectively open justice to take place, which of course is a paramount feature of the English legal system. And that principle of open justice was something the Lord Chief Justice very early on in 19th of March or thereabouts was taking the lead on in relation to basically saying the courts will remain open, essentially through using technology, and only in cases where virtual hearings can't take place will there be exceptions where adjournments might be until after COVID is over, or some other means. So we also had a whole conglomeration, as this slide shows, of events that took place towards the end of March. In addition to the Lord Chief Justice's message, we've got obviously statutory provisions through the Coronavirus Act and statutory instruments and regulations that are affecting our lives in many different ways, but also in relation to the ability and the progress of actions through our courts. And in addition to that, practice directions such as 51Y in terms of audio and video hearings, and a publication of a very important protocol regarding remote hearings, which was nice and succinct and to the point, and I think helped a lot of practitioners get started. Yeah, and as that slide shows, this approach, very much the kind of British way, keep calm and carry on, is obviously a very key feature. And what's been refreshing in relation to the courts has been the use of business mediums that some of us have been using in commercial law with our clients, like Skype for Business and so forth, and Zoom. But the courts are showing themselves to be ambidextrous in relation to both these platforms and other platforms, alternatively suggested sometimes if there are issues with those platforms for one reason and another. And as I'm sure, Finola, you will speak to, the courts have, although with lots of court officials working from home and clerks working from home, etc., the courts are, the gears of the court system are keeping moving, rather than justice denied with court hearings being put off to some long distant time, which was obviously totally unsatisfactory.
Yes, yes, the courts tried to continue business as usual. Initially, I think they were optimistic that they could continue to hold live physical hearings in court. And certainly that was the intention, week commencing the 19th of March. Very rapidly, it was recognised that that wasn't going to be possible. And of course, we then had lockdown introduced on the 23rd of March. We certainly in the roles building introduced a protocol for remote hearings, and the TCC was able to get out template orders for both short adjudication enforcement and also for longer trials, so that the hearings could go ahead remotely. The staff continued to process electronic applications by CE file, and I think that's gone pretty well. Obviously, there have been a few hiccups, but generally speaking, the TCC has managed to continue business pretty much as usual in terms of throughput of business. Of course, some trials had to be adjourned. In particular, some of the procurement hearings needed to be put off, but that was primarily because they involved the NHS trusts or healthcare providers who quite naturally needed to focus on other things that were going on. And also there were cases where witnesses or experts simply weren't available because they were self-isolating or ill. And this was a particular concern as we reached the peak of the pandemic. By way of example, there was one case that I was dealing with where the defendant was an Italian company based in Lombardy, and the experts weren't able to get to the facility to inspect it. The documents were in a facility to which there was no public access, and the witnesses, who many of whom needed interpreters, were all in lockdown. It simply wasn't going to work, so clearly the trial needed to be adjourned. But subject to that, I have been incredibly impressed by the fact that the parties, the judges, the court staff have all come together in order to make the wheels of justice continue to turn.
No, it's been, I mean, just, as I said, it's just spectacular how life has carried on. It just has not stopped. I think that probably takes us nicely on to some of the trends and issues we're seeing coming out of these cases. One thing that I've had a lot of conversations about is the issue of fairness. In some forms, I think we're hearing, possibly the family courts, that there may be situations where virtual proceedings may not be considered just or fair. And on the other hand, we have the, Professor Richard Susskind, president of the Society of Computers and Law, and he'll say in his book, The Online Courts and Future of Justice, that actually, if implemented correctly, all the boxes of fairness, of fair process and fair trials will be ticked. So I wonder whether, Finola, what your views on this are, and have you seen any issues in the TCC and the appropriateness of the fairness?
Well, I think the starting point is that for the justice system in general to work, there has to be fairness, and there also has to be a perception that hearings have been fair. And I think that for the most part, remote hearings have been very useful in keeping business moving. But my view is that there will still be some trials and hearings where probably the interests of justice are best served by having a live physical hearing. I think that there are sort of two main areas of concern in terms of fairness. The first is vulnerable litigants or parties. And obviously this was a particular concern in the Nuffield report into the family courts. First of all, litigants in person won't always appreciate the seriousness of a hearing that's conducted remotely. I think that's less likely to be a problem in the TCC, but was a problem identified in the family courts. I think that there is a problem for litigants and or witnesses and experts in terms of communicating during the course of a remote hearing. I know that everyone has adapted to using chat lines and so on during the course of a hearing, but nonetheless it is more difficult than it would be if everyone was in court. And I can still remember my days in practice where even during a very short adjournment, say of 10-15 minutes, that would be an opportunity for the parties and the lawyers to talk about strategy, a particular question that had been raised, and then the proceedings could move on. And I think that some of that is certainly compromised by way of a remote hearing. And although there are ways round it by way of technology, I think that it's not quite as satisfactory as being present, being able to whisper in the ear of a lawyer, for example, with a very quick response to a point that's being discussed, perhaps in cross-examination. It can also be harder for the court to identify when a witness is particularly vulnerable. So from that point of view, I think that the remote hearings are perhaps not quite as satisfactory. There's also the issue, which I think we'll come on to deal with in more detail, with how do you ensure that the whole process is fair when many of the participants are not directly in front of you. The second issue with regard to fairness is access for the public. We've gone a long way to try and ensure that the public do have access. Initially, I think it was thought that we could simply deal with that by relaying the remote hearing into the public courtrooms. But because we lost so many court staff, particularly following the lockdown, that proved actually just to be impracticable. We just couldn't make that work. It has been done for some of the very big hearings with a particular public interest. So, for example, last week one of the phone hacking cases was relayed in open court so that members of the public could come in. But of course, in practice, because of lockdown, people haven't been able to get to the courts. And so there is a real feeling that, that at the moment, the public doesn't have as much access to hearings as they did in the past. I think, though, on the positive side, the fact that we have been able to have remote hearings to which the press can have access, the fact that all remote hearings have to be recorded and therefore the transcripts can be made available to the public, have all gone to show that with the right setup, of course, there can be good public access to ensure that the hearings are fair, and that, of course, judges can be held accountable in terms of ensuring a fair process.
I wonder if that takes us on probably to the next issue, and you touched on this, I think, briefly before, were the issues of factual witnesses and experts. I know, or I've seen in the cases like the National Bank of Kazakhstan before Mr. Justice here, there were witnesses in that case, and then in the One Blackfriars case, Judge John Kimball QC is anticipating there being witnesses and experts in the trial to come, and no doubt there are things we need to be alive to with that. I wonder what your thoughts are, Finola, on this.
Well, I think that there is no bar on holding a remote hearing that is fair and transparent. Actually, regardless of its size, I think it really all depends on the nature of the issues that arise for the court to decide. So there's nothing to stop a remote hearing going ahead with a whole string of both factual and expert witnesses, provided that they are all well prepared, the technology is set up to work, and there are certain safeguards in place. And the safeguards that I think one wants in particular with witnesses of fact are to make sure that, first of all, they're not being prompted by anyone sitting beside them out of view of the camera. And secondly, that they're not being intimidated by anyone outside the reach of the camera. And also, I think there's a need to ensure that the evidence that they're giving is based on the documents that are made publicly available in court, and not by reference to answers being provided to them, maybe on an iPad, again, just out of reach of the camera. So I think those are the practical issues that can be faced in terms of ensuring that the process is a fair one. I think also there is the need to ensure that the witnesses can follow what is going on. One of the issues that has been raised, in fact, through trials that I've done with electronic documents, is the fact that if you simply have electronic documents flashing up on a screen for a witness in perhaps a complicated case, then they don't necessarily have an opportunity to read the whole of the document. And context is absolutely everything. It's all very well for the court to read the document and for the lawyers to be able to make submissions on it. But if the poor old witness of fact is simply shown one short paragraph out of context, then in fact the questions that are asked might be unfair. So again, I think it requires more thought and preparation than perhaps needed with live physical hearings. I also think that with experts, if it's a very technically complex issue, I think there is nothing to beat having the experts in court whether that's for hot tubbing or simply live cross-examination. I think that what you can miss through the remote hearings is some of the rapport and the spontaneity that you get through fast-paced cross-examination. And it's not just that I enjoy the theatre of it, it's that it actually can make for a fairer process.
Mm. And I suppose moving on to adjudication enforcements, perhaps if those are submission-only hearings, would that maybe perhaps lend themselves more to virtual hearings?
Yes, they do. I think that they are perfectly prepared for remote hearings. It seems to me that one of the issues for adjudication enforcement is how to have the enforcement hearing as quickly as possible and to conduct the hearing with as low a cost as possible. And I think that they do lend themselves to remote hearings very neatly. Primarily, it's done by way of documents with skeleton arguments where there is an issue of law or fact that the court needs to look at, because it tends to be a two-party hearing, save in very exceptional circumstances. It's easy to manage, easy to control. Very often there aren't that many documents, and provided the parties can then agree to file a common bundle electronically and a common bundle of authorities, I think they work very well indeed. And the same issues of fairness and so on tend not to arise.
Mm. Mm.
Yeah, and I think that's been a positive thing, certainly from the adjudication community and from clients as users, that the TCC has, and the special amendments to those forms that you devised in March, which are available and easy to download, show that enforcement can happen as per normal. So it's
Yes.
really good.
Yes, and the only issues that we had on enforcement actually were where parties were trying to serve outside the jurisdiction, because the foreign process service simply closed down.
Not much you can do about that.
Yeah.
Or deemed service, that's quite difficult.
Here we have on this slide, just a lot of questions are coming in now as to whether or not these slides will be available. They absolutely will. They'll be available on our website. And here you have the standard directions that Finola kindly has posted. I suppose that takes us on to what are the top tips for everyone out there, advocates, clients, solicitors. I mean, we've got plenty of articles and webinars now over the past month that have addressed the practicalities of dress appropriately, don't turn up in your pajamas, lock the door for the kids, the dogs, and everything else. But Simon, Finola, what from a judge's point of view, and Simon, what have you seen that you can particularly recommend?
Yeah, I mean, I think the question about making sure everyone understands what platform they're going to be on and how that platform works is obviously absolutely key. I think, like all things, the rewards come from preparation, and I think one mustn't underestimate that probably more preparation is required for virtual hearings than it is actually for potentially turning up in court in many ways, particularly because one's going to do a lot of nursing as a solicitor anyway in relation to the client, communication in relation to making sure their engagement is something which is positive for the solicitor and the advocate, and also making sure that any witnesses are also eased in and understand their role and the significance of their role isn't in some way kind of a second grade sort of affair. But communication is very important, I think, into solicitor. That I think one of the good things about this COVID situation is, and I think I can say it as a generalization from my 2 months anyway, is that I think there's more cooperation going on between solicitors and I think between lawyers about the process because it's a common problem. And I think that's actually probably helping this situation be less of an arduous affair than it might otherwise have been.
Yeah. Yes, I mean, I would agree that that remote hearings do require more preparation. I think they're probably a bit more tiring than
Yes.
physical live hearings. And therefore, as a judge, I think it's important to build in short breaks, if necessary, to allow a bit of a breather. I think in terms of tips, there are some really basic things. Make sure that if you're using a laptop, that it's fully charged or you've plugged it in before you start. If you've got lots of devices, make sure that they're not close to the one on which you're connecting, because otherwise that can involve interference. Make sure if there are lots of people on the call or the meeting that everyone has muted their microphone, otherwise there's horrendous feedback. If you've got small children, try and give them something else to do before you start the hearing. And I think also it's quite important to make sure that when you're speaking in a remote hearing, that you speak probably slightly slower and probably slightly clearer than you would otherwise do, because there can be a slight delay, and even having sort of made sure that you've excluded all of your surrounding noise, it can sometimes be harder to follow. So I think those would be my top tips, except for the final one, which is generally, if you've got an important hearing coming up, I think it is vitally important that you do some form of test run.
Yeah.
And I think that that's going to be critical if there are a number of witnesses, whether factual or expert, because I think that's where the ability of the wheels to come off the bus are likely to emerge. But just one final point, which is, of course, there are going to be technical hitches in the hearings. I think everyone just has to accept that if they happen, so be it. You simply pause, leave the meeting, try and rejoin, have a short adjournment, and of course, if things go badly wrong, then you just have to adjourn it and have the hearing at another time or on another day. It's not the end of the world.
Yes, I think you need to build in some sort of redundancy in your hardware, basically at home, to allow for that sort of situation. I was hearing and speaking to a partner earlier on today who had a mediation and a power cut going on just as that opening statement was being made, and having to jump into a car and drive 2 miles to their parents' house to hook up and complete their submissions. But the process was allowed for. But it just shows sometimes with all the best planning you can't always allow for those things. So being tolerant where parties have genuinely got into a situation is necessary.
Yeah.
I suppose that takes us on to mediations now and arbitrations, and not all of the world is in the courts. So Simon, I wonder whether you've got any few points on what's happening out there with arbitration and mediation for these power cuts.
Yeah, well, I think the arbitral world is essentially, I think, match fit in relation to virtual hearings. A number of arbitral institutions have for some years now, certainly the last 2 or 3 years, invoked and drawn up various kind of protocols and guidance for virtual hearings. And there's certainly London Court of Arbitration, SIAC, the Stockholm Chamber of Commerce, ICC, all have in recent weeks published fresh guidance for parties and participants in arbitral process to ensure that arbitrations, where possible, do go ahead. And I think certainly speaking to fellow arbitrators and others on the circuit, one can see that a lot of arbitral business is continuing. Some hearings, because of time differences, are causing a major problem if there's parties in different parts of the world and you can't really find a happy medium. But I think as far as arbitrations proceeding virtually, they're not really having huge problems.
Super.
And yeah, for mediation again in a very similar way with the various mediation bodies, the kind of ones that we're all familiar with, like CEDA, etc., have established their own guidance and notes and procedures to allow parties to get the most out of virtual hearings, and there are providers like Zoom, Starleaf, GoToMeet, Meeting, Cisco WebEx, etc., which are all happily being adapted for mediation hearings, and the ability to have caucus sessions in private rooms. One hears disaster stories about mediators going into the wrong room and hearing the wrong conversation, but I don't think we're hearing too many of those. I'm sure there are instances where things can go wrong, but they go wrong in the real world, when sometimes the mediator might say something to one of the parties which perhaps they shouldn't have done. So yeah, I don't see any problems in business as usual there.
Yeah. And I suppose now, finally turning to the future of virtual hearings, is this here to stay? Is this temporary, or have we seen a fundamental sea change in the process of dispute resolution? I wonder, Finola, your view.
Yeah. Well, I think first of all, I have been pleasantly surprised and very impressed, actually, with the ability of everyone, from the judges, the court staff, the solicitors, counsel, and witnesses and parties, to adapt. I think that there has been amazing cooperation, and there might not have been, and also agility. I think that people have been very quick to adapt to the new scenarios that they've been presented with, and they've simply got on with it. People have made things work, and certainly the courts couldn't have continued to function unless there was that great cooperation between all of the individuals and organisations that have been involved in the justice system. I think that it has shown us that we actually need to evolve in order to serve the interests of justice in the future. I think that we should be more proactive in trying to make technology work to produce efficiencies in terms of cost and time and access to justice. Of course, we know that the Supreme Court has been relaying its hearings for some time, I think with great success. I don't think we're quite ready for that to be extended throughout the whole judicial system, but I think it shows that the technology is there. We simply have to work out how to make it work for us in the future. And I think the example of adjudication enforcement is one that could readily be continued, not necessarily in every case, but offered to many people, even once we resume our live physical hearings. However, the final note is that I predict that we will go back to some physical hearings where appropriate, and I think that's the right thing to do. I know that in some particularly complex cases, the parties want their day in court, and I think that in those circumstances, if the court can offer them a live hearing, they should do so. The Roles Building is offering from beginning of June some physical hearings. There are only 13 courts available, and that serves the entire Chancery, commercial and TCC courts. So I think the vast majority of cases will continue to be dealt with remotely, but it does mean that in those cases where the parties feel that in order to have a fair hearing, they want it to be a live physical hearing, the courts will be able to offer that to them. I think that there will always be a place for live physical hearings, but I think that we can and should make better use of technology in the future.
Thank you very much. Sorry, Simon. There you go.
Yeah, I mean, I share all those kind of views from the kind of solicitor's angle. I think that there probably will be a permanent change in the sense that I'm sure we will go back to actual hearings in person, but I think that there'll be quite a lot more streamlining in relation to litigation. I think general counsel that we deal with on for a number of clients are already saying that they can see the benefits in reducing costs and efficiency through using technology. I think that the proclivity of parties to jump on aeroplanes and fly experts all over the world might reduce slightly with the ability to do things remotely. I think even with things like drones, you know, site visits by judges probably might not happen quite so often. Not that they happen every day of the week, but I think overall, hopefully we will get back to some sort of business as usual. But I think that new normal is kind of possibly here for a long time. I.e., that's the way we're going to go.
Yes.
No, absolutely. I wonder whether now we'll take a few questions from the audience. We've had similar questions come in from what you've been talking about throughout. Apologies if there's feedback I'm hearing for myself. I think several questions have come in about documents. And is there anything that parties should be doing with hearing bundles, trial bundles, how to organize them to ensure, to the extent possible, everything goes smoothly?
Yeah. Yes. I have to say, documents was a bit of an issue at the beginning. For example, I was doing a hearing where I wanted to give an extemporary judgment. And then as I started to give the judgment, I realized that the documents were all over the place and I was having to scroll through documents and cases to find the relevant bits to quote from. And I thought, oh, I hadn't really thought this through before I started. And it was fine. It wasn't a very long extemporary judgment, but it did bring home to me the importance of sorting out all of the documents well in advance. So the first thing is, please try and agree bundles with the other side and lodge them well in advance.
Yeah.
So that if there are any issues, they can be sorted out before the hearing starts. Secondly, do think about how you're going to access individual documents and bits of documents during the course of the hearing. I had a hearing the other day where I had a wonderful PDF bundle and it had the index at the front, all with hyperlinks to the documents. And also, when I opened each document, there was a table of contents down the left-hand side. So it made it very, very easy to navigate between different documents and find what it was we needed to look at. And so I think really it's all about thinking ahead, working out how you need to organise the documents and knowing how you're going to access them in the middle of submissions or cross-examination before you get to the hearing.
Yeah, I think core bundles and really essential documents is something that has to be looked at very, very closely because you know, it is very difficult to accommodate the volume of documents one could have in a live hearing situation with all the benefits of court support and the likes of the Opuses and the Epic, etc., that do these kind of services. But yeah, I think solicitors need to think about the mediums in which and the way documents open, like in PDF, that's quite quick. You can hyperlink within it, and you know, it works. It's not, you know, getting it right actually helps the whole administration of justice machine. It's not just assisting your opponent or yourself or the judge, it's assisting the process. So I think that's really, really important.
Yeah.
So I'm gonna put the next question to you because I can hear your sound is so clear. There's a question coming about costs in adjudication and whether if you have a virtual adjudication, would you expect your costs to be lower?
Well, I mean, in one sense, so much of adjudication is documents only. The only difference, maybe there's a little bit less travel by solicitors who are acting in relation to those cases, but the same would apply to claims surveyors and so forth. I think the costs of the process are pretty lean because we've had 20 years of specializing in adjudication disputes. So I think there's going to be less reprographic costs. I think insisting on hard copy bundles has died a death in March, and I don't think that's possibly going to come back. I think portals and downloads is pretty normal anyway, so I think possibly less.
Okay.
Slightly on disbursements.
We've had a question about as everyone starts to return to their offices, would it be beneficial for law firms to convert a meeting room into a virtual hearing room? And how could we assess which hearings require physical court presence and which hearings could be virtual?
I think a lot of law firms are setting up studios already, and certainly a lot of international law firms have done that. And I think that, you know, even in our own firm, I can see that happening. You know, whether we get out of COVID or we don't, you know, there's going to become a point when there's going to be some return to the office, and there is going to still be a restriction in certain jurisdictions as COVID goes around the planet, where some people aren't willing to or not able to travel. So I think we are going to see more of that, and we need to really.
And possibly our last question here, Finola, the length of hearing. We have some questions relating to, do you see any difference in the time it's taking to do the hearing relative to what it would have done in a physical situation? And should solicitors change time estimates?
Yes, I think it does depend on the nature of the hearing. So if it's a hearing that primarily is based on submissions and documents, then probably there doesn't really need to be a change in the estimate. Although I think it's important for actually parties to indicate if they need additional breaks. And the judge also should watch to see whether people are managing to concentrate for the entire hearing. And so there might be a little bit of extra time needed in standard hearings. But I think for hearings that involve witnesses, it's likely that those hearings are going to require an increased estimate. I think that the questioning of witnesses can take a bit longer. There can be delays because of technical issues. It can also take the witnesses a bit longer to find the relevant documents. And also there can be a slight delay in the question and answering with witnesses. I know it's something that I used to find slightly frustrating if I had to cross-examine a witness by video link, but it's the new reality, so we simply have to deal with it. I think in cases where there are a large number of witnesses, there will need to be a longer time estimate needed.
Great, thank you very much. I think looking at the time there, we shall end on that. But thank you everyone in the audience for submitting questions, and do feel free to email either Simon or myself if you think of anything in due course. But before we go, may I say a huge thank you to Finola and Simon for such a detailed and stimulating session. I thoroughly enjoyed it, and no doubt our audience did as well. And thank you to the audience for joining us. A copy of the slides will be made available, of course, and we do hope that you can join us next week, same time, same place, where we will have our managing partner, Tony Francis, chairing a discussion between Annalisa Day, QC, and our partner, Claire King, on on-demand bonds and performance guarantee. Thank you again, everyone. And on behalf of Fenwick Elliott, we hope you're keeping safe and well, and we look forward to seeing you again very soon. So thank you, Finola, Simon, everyone. Take care.
Thank you.
Bye.